to the functioning of courts for a person seeking to enter judicial service. We find considerable force in the reasoning that a civil judge from the very first day in office is required to deal with matters affecting life, liberty, property, and personal rights, and therefore the familiarity with the actual working of courts, courtroom procedure, and the respective roles of the bench and bar is necessary. We are, however, of the view that a requirement of prior experience must also be a reasonable relationship to the object it seeks to achieve, and that the sudden restoration of the requirement without any transitional arrangement has visited hardship upon law graduates who had prepared their professional lives on the basis of the regime that prevailed for over 2 decades. Having considered the arguments advanced by the parties, the learned amicus, and the suggestions received from the high courts, law universities, national law schools, we have concluded that the judgment under review does not require reconsideration on the desirability of practical experience, but that a limited intervention is warranted in the manner in which the 3-year requirement is to be brought into operation. We are accordingly of the opinion that the object underlying the 3-year requirement can be achieved not merely through conventional practice at the bar, but through a structured combination of institutional training at the state judicial academies and supervised law clerkship, which shall be treated as equivalent to practice at the bar for the purposes of eligibility. Then the directions that we have issued, I will just comprehensive.
Modified.
We have said, in light of the above discussion, we consider it appropriate to issue the following directions, which would apply to all recruitment notifications, advertisements issued to the post of civil judge unit division in the transitional period, namely from the date the judgment was in May 25 pronounced and up to 31st March 2027. The directions are: all law graduates shall be eligible to apply, notwithstanding the 3-year practice requirement, having regard to the fact that more than 1 year has elapsed since the judgment under review was pronounced. Such candidates shall, for the purposes of their applications, be deemed to have completed 1 year of active practice. They shall not be required to furnish a separate certificate of practice in support of the said deemed period. Second, candidates selected pursuant to the aforesaid recruitment shall, upon appointment, be designated as trainee judicial officers and shall undergo a compulsory period of 1 year of intensive training at the concerned state judicial academy. This period shall be treated as equivalent to 1 year of practice at the bar for the purposes of the 3-year requirement. During the period of such training, the trainee judicial officer shall be paid a fixed emolument equivalent to 1/2 of the remuneration payable to a judicial magistrate. We are completely changing the concept now. First class in the they shall in addition be entitled to the facilities and other benefits ordinarily made available to trainees at the concerned state judicial academy. Upon successful completion of the aforesaid training, the trainee judicial officer shall undergo a further period of 1 year of structured law clerkship. The first 6 months shall be spent as a law clerk under the supervision of the principal district judge, district and session judges, or members of the higher judicial services, and the remaining 6 months under the supervision of a sitting judge of the concerned high court. The aforesaid 1 year period of law clerkship shall also be treated as equivalent to 1 year of practice at the bar for the purposes of satisfying the 3-year requirement. During the period of law clerkship, the trainee judicial officer shall be paid same emoluments as admissible during their training in state judicial academies, with no further allowances, etc. Upon completion of the law clerkship, the sitting judge of the High Court under whose supervision the trainee judicial officer has served shall submit a reasoned evaluation report concerning the performance and suitability of the trainee. Upon such evaluation being found satisfactory, the trainee judicial officer shall be appointed to the regular post in the field and shall thereafter be entitled to regular pay scale and other service benefits attached to the post. We further direct that for the period following the transition period, that is notification advertisement issued on or after 1st April 2027, the following directions shall govern the recruitment to the post of civil judge. There we have said every candidate seeking to appear for the examination for appointment as civil judge unit division shall possess at least 1 year of actual practice from the source and certification as laid down in direction number 7 and 8 of the judgment under review for now and thereafter as laid down hereinafter. Such practice shall be subject to verification through issuance of a certificate of practice, which shall not be issued unless the candidate's presence and participation in effective judicial proceedings whether along with a senior member of the bar with at least 10 years practice or otherwise, have been duly recorded in accordance with the mechanism to be prescribed by the High Courts. The application of a candidate for recruitment to judicial service from the aforesaid recruitment cycle shall be entertained only upon submission of the requisite certificate evidencing completion of 1 year of actual practice in the district courts. Candidates, next direction is candidates selected pursuant to such recruitment shall, notwithstanding their 1 year of prior practice, undergo the same 1 year period of intensive training at the State Judicial Academy, followed by 6 months of law clerkship under the principal district and session judge and member of the higher judicial service, and thereafter another 6 months of law clerkship under a sitting judge of the concerned High Court in terms of direction 2 and 7 of paragraph 73 that we have already explained in detail. For abundant caution, we reiterate that all notification advertisements issued already after the judgment and review was pronounced, as well as notification advertisement to be issued hereinafter for recruitment to the post of civil judge junior division shall conform to and will be governed by the aforesaid directions. The state governments, in consultation with jurisdictional high court, shall undertake and officially notify necessary amendments in the applicable service rules forthwith, and in any case within 3 months from the date of the judgment. We may also observe that the directions issued herein above should adequately address the grievances expressed by the petitioners in red petition number 1110 of 25, particularly with respect to the need for appropriate accommodation for persons with disabilities. In our considered opinion, it merits clarification that the scheme, now this is very important, the scheme formulated herein should not be made immutable. Judicial recruitment is an evolving process, and the effect of the present arrangement can be properly assessed only after it has operated for a reasonable period. A period of 3 years would provide sufficient institutional experience to evaluate whether the combination of limited prior practice, structured training, and supervised clerkship is achieving the desired objective. This court may thereafter revisit the scheme on the basis of material concerning the quality of recruitment, performance of trainees, adequacy of training, and other relevant indicators. Therefore, scheme contained in these directions shall remain in force for a period of 5 years from the date of the judgment. Upon completion of the said period, the working of this scheme, including the quality of recruitment, the nature and efficacy of training and clerkship, the performance of officers recruited under the scheme, and such other empirical material as may be relevant, shall be placed before this court for its consideration, and the scheme shall thereafter be revisited if necessary. So, with these directions, we have modified this. Of that post graduation should be treated equivalent to practice, that we have not been able to accept.
Very well.
With due respect, I am unable to concur. The review petitions stand dismissed.
Grateful.
Great. Lordships, we are very grateful for a very pragmatic scheme, your Lordships. The youngsters are going to be very grateful to Lordships for this.
See, we hope that this is a workable solution.
Yes,
that's why we have not put it as a permanent remedy. It's a transitional
Yes,
over part. So let us see after a couple of years how it works.
Yes.
How does it help the youngsters? Is it a effective instrument to bring best of the talent to the judicial service?
Please, your Lordship.
Entire purpose is this one. So that's why we ourselves have said that it needs to be revisited after some time. We don't want to create any moral pressure that there is a judgment and why it should be.
That's why I said, your Lordships, it's very pragmatic and practical, because we'll now see how it works on ground.